Hi, this is Justin Bathen on Torts and Immunity for Kentucky School of Law. Now, torts and immunity is a big topic, and we're going to hit some highlights throughout these, just giving you a broad sense of the law in this particular area. All right, first off, when you think of torts, I understand that most folks think of, some kind of dessert of some kind. This is a legal concept which has a word that very few folks are unfamiliar with, but it's a big legal concept that you probably have a pretty general sense of already, just being an American citizen. And really what we're dealing with when we deal with torts are injuries, human-to-human injuries. And remember, these are not criminal things, right? When a criminal case happens, it is the government that is suing a particular citizen because they broke some kind of criminal law. In this case, this is one citizen harming another citizen and that citizen suing the other one. And that injury we call a tort. And as you'll see, there's different kinds of injuries that can unfold, some of which we're going to hold teachers liable for and principals, and some of those we are not going to hold teachers and principals liable for. So that's the kind of stuff we're going to talk about in this module, all about injuries, when kids get injured at school, when teachers get injured at school, that kind of stuff. So this is sort of a fancier way of saying those same things. Here in the United States, we all sort of have this relationship with each other. We have these mandatory obligations to each other. And when we break those mandatory obligations, citizen to citizen, that's when we decide that that thing is going to be called a tort. Now, all of the law in this area, almost all of it, except for some of the immunity provisions, is stuff that has been developed in case law over time in the courts. Very little of this gets written down in a statutory kind of way. So this is an area of law, injuries, where courts have made almost all of the law that is relevant to us in schools. Okay, great. Now let's ask this question of what is negligence. So the vast majority of the torts that we have going on in society are negligent torts, where one person's inactions or actions negligently harmed another person. And when we say negligently, we mean there's no intention. There's no will to harm someone else. It's not thinking, hey, I'm going to hurt this other person, I'm going to hurt this kid. It is you did something and accidentally caused harm to another person. Still, though, that harm that you caused to another person potentially is something that we are going to deal with in the court system. And so that is what's negligence. Now, how do we know whether or not negligence occurs? Now, we have this beautiful 4-part test to determine whether or not negligence has happened. And this 4-part test has been developed and long used by the courts. And so we have this really easy, simple packaging of what it is that makes negligence happen. It's those circles down there at the bottom. Injury plus duty plus breach of duty plus causation is equal to negligence. So let's take a little bit of a deeper dive into those components. So first, on the injury side, this really is just an injury of some kind, either to the body or to property. Okay, so it doesn't have to be always some person getting physically hurt. It could be that you cost somebody a whole bunch of money, and that is a property injury, for instance. Okay, so something that has harmed someone else. There has to be actual harm here. Not theoretical harm, actual harm that has happened. Second, there has to be a duty from one person to the next. And this duty, these things are things that get implied in schooling and in all other elements of society. Like when you're driving in a car, there's a lot of duties that you assume by driving a car, that you're going to stop at stop signs and all kinds of stuff. And some of that stuff gets labeled as criminal, but a lot of that also is just sort of the duties that we share as a society. Okay, so you have a duty of reasonable care. Inside of schools, we have proper instruction, adequate supervision, to maintain facilities and grounds, a duty to warn a kid if some injury might result. And the big one we have in schools that you don't see in other elements of society is that schools are held in loco parentis, which is just fancy Latin way of saying in lieu of parents, of course, that we hold teachers in loco parentis so that they have the same duties that a parent has to a child teachers have those duties and principles while they're in schools, okay? So those are the duties that you have to a kid in the school, to another adult in the school. Then there has to be a breach of that duty, like there has to be some action or inaction that breached the reasonable care, in loco parentis, or the duty to maintain the grounds. Something has to have happened that breached the duty, and then that breach has to be the cause of the injury, okay? So it all has to sort of circle back around. There has to be an injury, has to be a duty from one human to another, a breach of that duty, and then that breach must have caused the injury, okay? And we ask this question, but for that breach of the duty, this injury would not have happened. That helps us determine whether or not there was causation. Okay, super, so that is negligence, and now that you know this particular test, probably what you're thinking is, oh my gosh, this happens all the time in schools. And yes, you're right, it absolutely does happen all the time in schools. Now, you're lucky because there are defenses to negligence, and one of them is massive when it comes to schools. So normal defenses to negligence that apply across society are contributory or comparative negligence, where we try to balance and figure out who's the one most at fault, right? So sometimes the school is not most at fault. The kid injured another kid, and that's the one most at fault. Sometimes there is an assumption of the risk where kids or adults sort of knew that they were going to take on additional risk. And of course, sports falls into a lot of this. Now that said, kids really cannot sign away their rights. Schools love to try to get around this with permission slips, but rarely do courts like permission slips in terms of waiving negligence. So you can try it. It doesn't always work, but there might be some times where assumption of the risk applies in the schooling context. Now the big one, though, is governmental immunity to negligence. And as we established in our first meetings together, you are the government if you work at a public school. All right, so we really have to wrestle with this concept of governmental immunity then. So let's dive deeper on that. So we have a statute that gives us some guidance on when are we going to apply immunity to governmental employees in Kentucky. And of course, being a public school, you're a governmental entity. Now, what really is going to matter here is we're going to apply immunity when the actor, the principal or the teacher, is making a discretionary choice, when there are multiple options available and they're having to pick between multiple good options, and you make sort of a positive discretionary choice. We're going to give you immunity on that choice. Okay, so if you're making a decision of whether or not to discipline a kid, that's sort of a discretionary choice. It's not a ministerial choice. Now, ministerial, we are not going to protect with immunity. Ministerial choices are you simply doing your job that has been clearly articulated in advance, right? So cleaning up the floor after a spill. No doubt about that. You have to do that, especially if you are the custodian, right? Like that is literally the job. That's not a choice you need to make whether or not to clean up that spill. It is your job. And so it's ministerial in nature, and we're not going to provide immunity if you fail to do your very clearly articulated job. However, when it is the sort of a decision that's not clearly articulated and you're having to wrestle with what to do in this particular instance, teacher evaluations, you can see I have some examples up there. Those things are discretionary, and we're going to protect the choices that are made against negligence in all of those contexts. Okay, so that winds up protecting a whole bunch of things that might otherwise be determined to be negligence in schools, and you can see some of those examples in cases that I've linked up in the readings. Okay, great. So one big question that you might be having is, now all this negligence that's happening in schools, what happens if kids sue us for failing to get a great education, right? Like what happens if a kid goes all the way through 12 years of school, at the end of it can't read at a 4th grade level? Well, malpractice is something that we have never allowed to be applied in the schooling context. In a hospital context, if a doctor does a surgery and the whole surgery fails, we would sue that doctor for malpractice. But we've never held schools to the same kind of responsibilities in terms of malpractice. And so educational malpractice, no, it is a small piece of, it is a thing that just doesn't apply to schools. All right, a few more things to talk about. Now, that whole time we've been talking about unintentional torts, accidents. Now, let's turn to intentional torts. What happens when one person actually does want to harm another person? There's intention to harm another person. Now, that stuff is absolutely not protected. And there are different kinds of these intentional torts, but we're always going to hold principals and teachers accountable when they commit intentional torts. So let's take a look at a few. Assault and battery. So these two go together a lot. You hear them talked about a lot. Assault is not the actual harming. Assault is the fear of harming. So we are going to threaten another person. That's an assault. Now, actually hitting that other person is a battery, right? The actual intentional striking of someone else. So when you see fights happening in schools, well, there's a battery happening. And you hope that, the adults are not actually participating. But if they do, and we had a case in Lexington a few years ago where a school resource officer threw a punch, that is a battery, right? Now, in that instance, the resource officer didn't talk about the punch in advance. They didn't threaten the punch. So there was no assault in that case. It was simply a battery. But if you sort of threaten the assault and then you actually do hit someone, well, that's an assault and a battery. See how those two work together? Okay, great. Let's move forward. Another intentional tort is false imprisonment. Now, in schools, we imprison children a lot. Now, that's a big word, I understand, but in this legal context, we hold students sort of captive in their freedom of movement by keeping them in classrooms or putting them in a timeout room or a suspension room, something like that. That happens all the time in schools, but this can rise to a level where it reaches an intentional tort of false imprisonment. If we are like duct taping a kid to a chair, for instance, that's false imprisonment. Used to be popular, teachers would draw a circle on the board, especially elementary, and have the kid put their nose in the circle and leave them there for 20 minutes, maybe an hour. That would be false imprisonment. Even though the kid could move, the adult is imprisoning them mentally in that space. That could be false imprisonment. So be careful about how restrained you make kids. Now, we're going to talk about restraint and seclusion in a different part of this class, but if it rises to a high level, it could be false imprisonment. And then there's an intentional infliction of emotional distress. Now, I think this happens more in schools than comes out in the court system. It's rarely used. However, when there is sort of harassment and bullying really rising to a high level, especially if it's adult to kid harassment and bullying, another tort might actually apply in that instance of intentional infliction of emotional distress in sort of a sustained, severe mental anguish. Let's say a teacher has made fun of a kid for years. That could be intentional infliction of emotional distress. Let's say a sports coach is, absolutely tearing a kid apart, making them run tons of drills, and just really bearing down on them, sort of harassing them mentally. That could be intentional infliction of emotional distress as an intentional tort. Now, always keep an eye on those things. Last slide to talk about is around defamation. Now, defamation is also an intentional tort, and so it falls in this area, but it's sort of a different kind of concept. And sometimes this comes up for teachers and principals and superintendents, and so it's something to put on the table. Defamation is a big topic that has two categories, slander and libel. Right? Slander is always things that are spoken, and libel are always things that are written. Writings, pictures, movies, that kind of stuff that actually is sort of a physical document of some kind, whereas slander is always just sort of spoken, like at an SBDM meeting or something. That could be a slander. Now, to determine whether or not these two things have happened, we have a 3-part test for private individuals, a 4-part test for public individuals. If the actual first element of defamation is the thing that is spoken or written must actually be false. So if they're saying something that's sort of true but very hurtful, well, if it's truthful, it's not defamation. It has to be heard and understood by a third party, and there has to be an injury resulting from that speech. And then if you're a public individual, and a superintendent, especially in a large district, would be a public individual, a superintendent of Fayette County Public Schools, Lexington here, they would be a public individual. They also have a fourth element of the test where the person doing the slander or the libel must be making it with malice and reckless disregard for the truth, right? Because for public individuals, comedians make jokes about public individuals all the time. But there's not a lot of malice there. It's, funny, making jokes. That stuff is not defamation. Okay, that is torts. It's a lot there. I'm sorry. Thanks for making it all the way through the module. But you can see that injuries can take many different shapes and forms. When those injuries rise to certain levels, people can be held accountable, potentially even personally accountable if immunity is not provided to the educator. And of course, anytime an educator engages in intentional harming of someone else, that of course will not be protected, and we're always going to hold them accountable, and most of the time they'll lose their job. Thanks for watching.